Hi, I'm Dan Kuperstein, and welcome to this episode of Compliance Minute. In December of 2015, the IRS issued guidance on a number of topics pertaining to the Affordable Care Act in IRS Notice 2015-87, including very helpful guidance about the impact of a cafeteria plan's opt-out arrangement on the ACA's affordability requirement, which is what we're going to discuss in today's episode. But to provide some background, IRS Notice 2015-87, referred to as the Potluck Notice because it has so many different topics included in it, discusses, among other things, the effect of HRA contributions and cafeteria plan flex credits on such ACA affordability determinations, as well as providing much welcome clarifications pertaining to fringe benefit payments under the McNamara-O'Hara Service Contract Act, or SCA, and other similar laws. So what are opt-out payments, and why is this notice so important? An opt-out payment is a payment that is given by an employer to an employee to waive health insurance coverage, and the amount cannot be used to pay for coverage under the employer's group health plan. Such arrangements can be either unconditional, that is, an arrangement providing for an opt-out payment conditioned solely on an employee declining coverage, or they can be conditional, that is, for example, an arrangement that requires the employee to provide proof of coverage provided through a spouse's employer. Significantly, the IRS views opt-out payments as increasing the amount of the employee's required contribution for purposes of determining affordability under the ACA's pay or play, or employer shared responsibility rules, and will be soon publishing regulations to that effect. So how does this work? As an example, if an employer offers employees group health plan coverage through a Section 125 cafeteria plan, requiring employees who elect self-only coverage to contribute $200 per month toward the cost of that coverage, and the employer offers an additional $100 per month in taxable wages to each employee who declines the coverage, the offer of $100 additional compensation has, in the economic effect in the eyes of the IRS, of increasing the employee's contribution for that coverage. So in this example, the cost of the employee's contribution for the group health plan would be $300 per month. Consistent with this analysis, the IRS has determined that it is appropriate to treat an unconditional opt-out arrangement, that is, that arrangement conditioned solely on the employee declining coverage without any proof of anything else, in the same way as a salary reduction, thereby increasing the amount of the employee's contribution for ACA affordability purposes and for ACA information reporting purposes. Fortunately, the IRS indicated that compliance with this rule will generally only take effect after final regulations have been issued, with the exception of unconditional opt-out arrangements adopted after December 16th of 2015. Accordingly, prior to the release of these regulations, when employers are determining compliance with the ACA's affordability requirement and completing ACA information reporting, employers are not required to increase the amount of the employee's contribution by the amount of the opt-out payment, provided that the opt-out arrangement was adopted by the employer on or prior to December 16th of 2015. For more information on this and other topics, please visit our Knowledge Center at corpsyn.com. Thank you.